Hello, I am Gagan. In this video, I will offer a simple overview of the Indian Penal Code 1860. For the benefit of the viewers, this lecture is divided into various parts and you are at freedom to navigate to any part using the chapters feature available on YouTube. Timestamps are given in the description. You may also change the speed of this video as per your convenience. Introduction to criminal law. As you may be aware, there are two types of wrongs, civil and criminal. While civil wrongs are less serious, criminal wrongs are more serious and affect the society at large. For example, if a person breaches a contract, it affects only those parties signing the contract. Whereas a murder happening in a locality affects not just the victim, but the people living in that place and beyond. Recall how the Nirbhaya incident of 2012 affected the whole nation. Criminal law in India mainly consists of the Indian Penal Code 1860, the Criminal Procedure Code 1973, and the Indian Evidence Act 1872. The Penal Code is the law which defines the various acts that are considered to be criminal and prescribes the punishment for those crimes. The Criminal Procedure Code lays down the procedure to be followed in criminal trials. The Evidence Act provides guidelines on what type of evidence is admissible in the court. These three laws together guide the court in a criminal trial. In this lecture, we are concerned with the Indian Penal Code only. But before getting into the Indian Penal Code, it is important to discuss the various mental elements in crime and the making of Indian Penal Code. Mental elements in crime. In the book Autobiography of a Yogi, the author Paramahamsa Yogananda narrates an incident where he raised his hand to kill a mosquito and stopped midway. Yogananda's master asks him, "Why didn't you finish the job?" Yogananda exclaims, "Master, do you advocate taking life?" Master clarifies, "No, but the death blow already had been struck in your mind." The master here is speaking about the mental element. Mental elements in crime. There are two elements in a crime, the mental element and the physical element. For example, when a person picks up a gun with an intention to kill another person, there is presence of mental element to kill. The moment the trigger of the gun is pulled and the victim is hit with the bullet, the physical element is completed. All through the Indian Penal Code, the various forms of mental elements of crime are discussed. Some of the mental elements that we come across in the Penal Code are intention, motive, mens rea, knowledge, innocence. Let us discuss intention, motive, and mens rea in some detail. Intention. Recall your childhood days when you played with your friends. While playing, a friend would push you and you would get hurt. Sometimes you understood that your friend pushed you by accident. Sometimes there would be a person who would have pushed you purposefully to hurt you. This purpose is what we refer in criminal law as intention. We need to examine if a person did an act intentionally or accidentally. Intention means the purpose or design of doing an act forbidden by criminal law without just cause or excuse. An act is intentional if it exists in idea before it exists in fact. For example, if X first planned to kill Y and then kills Y, we can say that the intention exists. But if X is cleaning the rifle and accidentally fires at Y, we can say there is no intention to kill but only physical action that killed. For most of the crimes defined in the Penal Code, proving the intention is crucial. We cannot read people's minds. Intention exists inside the mind, but the intention can be inferred from a person's outward conduct. For example, a person intending to kill another by using poison would purchase the poison and plan the murder. We can infer intention of a person from such conduct. Motive. Motive is different from intention. Motive is anything that can contribute to, give birth to, or even prevent any kind of action. For example, X, a robber, fires at Y, the watchman of a bank, so that X can rob the money from the bank. Here, robbing the money is the motive and killing the watchman is the intention. A crime is still a crime even if the motive behind the crime is pure. For example, X, a honest citizen, kills Y, a corrupt official to combat corruption. Even though X had a pure motive, X will still be punished. Motive is not mandatory element to be proved, but is helpful in cases involving circumstantial evidence. You can find more information about circumstantial evidence in the Evidence Act. Mens rea. Mens rea means guilty mind. This pertains to the mental element. Actus reus means guilty act. This pertains to the physical element. The maxim actus non fecit reum nisi mens sit rea means intent and act must both concur to constitute the crime. Take scenario 1. If I sit in my home dreaming that I need to kill a person, but I do not make any attempt to kill a person, no crime is committed. There is only mental element and there is no physical element here. Hence, there is no crime happening in this scenario. Take scenario 2. If a person fires at a bush to test his gun, but there was an innocent man sitting behind the bush who gets killed. In this scenario, there is guilty action of killing, but there is no intention to kill. Hence, even in this scenario, there is no crime. Take scenario 3. X picks up a gun and aims at Y's head and shoots. Y is killed immediately. In this scenario, the act of picking up a gun and aiming at Y's head is the outward conduct which shows that X intended to kill Y. The mental element is satisfied. The fact that he shot the bullet and killed Y satisfy the physical element. In this scenario, there is both mental and physical element, hence a crime is said to be committed. To make it easy, just remember this formula. Guilty mind plus guilty act equals crime. The three scenarios are compared in this table. In the first scenario, there is presence of guilty mind but absence of guilty act. Hence, it is not a crime. In the second scenario, there is presence of a guilty act but absence of a guilty mind. Hence, not a crime. In the third scenario, there is presence of guilty mind, there is presence of guilty act, hence it satisfies as crime. Although this is a general rule, there are many exceptions within the penal code. There are several crimes where, even in the absence of guilty mind, a guilty act would still be considered to be a crime. In the penal code, every provision that defines a crime specifically indicates whether the presence of mental element is necessary or not. Words that are used to connote the mental element are intentionally, voluntarily, knowingly, dishonestly, and fraudulently. If you wish to know more about the mental elements in crime, do check the book Outlines of Criminal Law by Kenny. Chapter 3 of this book deals with the mental elements in crime. If you are well versed with chapters 1 to 7 in this book, you will be able to understand IPC easily. If you need a copy of this ebook, contact me. Making of IPC. Before the British came to India, India was ruled by several rulers. The laws made by the rulers in each kingdom were followed. With the coming of British and establishment of various presidency courts, a mix of English law and Indian customs were applied to decide the disputes. Customary laws were applied based on the religion of the parties. In cases involving people belonging to different religions, there was confusion on the type of law to be applied. This led to hardship and anomalies in the administration of justice. In 1833, Lord Macaulay moved the House of Commons to codify a single criminal law for the whole of India. The Charter Act of 1833 introduced a single legislature for the whole of India and allowed the legislature to make a common law to Mohammedans and Hindus. The first law commission was constituted and Macaulay was its president. With the help of his colleagues, he drafted the Indian Penal Code and submitted it to the Governor General in Council on April 26, 1845. The draft saw several revisions by other commissions and experts. The Indian Penal Code was finally passed on 6 October 1860. Since then, the code has remained in force and has seen several amendments. In the aftermath of the Nirbhaya incident of 2012, the criminal laws relating to sexual offences were amended in the year 2013. This was a major amendment in the Indian Penal Code in the recent times. Structure of IPC. The Indian Penal Code in its original form consisted of a preamble, 23 chapters and 511 sections. Due to multiple amendments, these numbers may vary now. A set of sections dealing with the similar topics are grouped under a single chapter. Kindly note that for chapter numbers, Roman numerals are to be used, and for the sections, Arabic numerals are to be used. To make it convenient for the students, I have used Arabic numerals for chapters. Chapter 1 is titled as Introduction and consists of the preamble and the extent of operation of the code. Chapter 2 is titled as General Explanations. It contains definition of important technical terms that are used in the subsequent provisions. Chapter 3 deals with punishments. Chapter 4 deals with general exceptions. This chapter consists of exceptional situations where a person will not be held liable for wrongful acts. Chapters 5 to 23 consist of several chapters that deal with different types of offences. Each chapter is dedicated to one category of offences. For example, all offences relating to religion are placed under chapter 15. Let us now navigate to the important chapters one by one. Chapter 1 Introduction. Chapter 1 consists of a preamble and 5 provisions. The preamble of the code states, whereas it is expedient to provide a general penal code for India, it is enacted as follows. Section 1 to 5 basically deal with jurisdiction. Number 1. To what category of persons this code shall apply? For example, the code does not apply to foreign sovereigns. Presidents and prime ministers of other nations are not to be tried under this code. Number 2. The territorial extent of this code. The code applies to the whole of India. Interestingly, the code applies to criminal acts done on an Indian ship, even if it is sailing on high seas or anchored in a foreign country. Number 3. To what type of acts the code applies? For example, the code provides clarification as to the consequences when the ingredients overlap between the penal code and other laws. These aspects are important in cases where foreign nationals are involved or where the crime is committed in a different country. Some information about a contemporary development. Section 1 states that the code is not applicable to Jammu and Kashmir. Previously, the Ranbir Penal Code, passed during the reign of Maharaja Ranbir Singh, was in operation in Jammu and Kashmir. Due to the repeal of Article 370 and an amendment by the Union Government, the Indian Penal Code, along with many other laws, are applicable to Jammu and Kashmir from the year 2019. Chapter 2 General Explanations. This chapter consists of sections 6 to 52a. This chapter can be considered to be an interpretation chapter. The various technical terms used in the code are explained in detail. The definitions used in this chapter should be discussed while explaining the offences given in other chapters. For example, the words wrongful gain and wrongful loss defined in section 23 are relevant while discussing theft in section 378. The word good faith defined in section 52 is relevant while discussing general exceptions under sections 76 to 79. Section 34 dealing with common intention is usually a long essay question in exams. Students should be aware not to confuse between general explanations and general exceptions. Chapter 3 Punishments. Chapter 3 deals with punishments. Chapters 5 to 23 contain the various offences and punishment awarded for committing such offences. Those provisions just make a reference to the type of punishment given. For example, section 302 mentions that death penalty is awarded for murder. However, section 302 does not mention in what situations death penalty can be commuted to life imprisonment. Such detailed technical guidelines on punishments are dealt in chapter 3. Chapter 3 consists of sections 53 to 75. Section 53 states that 5 types of punishments are awarded in the Indian Penal Code. They are death, imprisonment for life, imprisonment that is either simple or rigorous, forfeiture of property, and fine. Chapter 4. General Exceptions. In this chapter, the various situations in which a person is not made liable for an offence are listed. As discussed earlier, mental element is necessary for convicting a person for an offence. It is believed that a child less than 7 years of age does not have the mental capacity to commit a crime. Hence, a child is exempted from criminal liability under Section 82. A person of unsound mind cannot distinguish between right and wrong, hence exempted from being held liable for criminal acts committed during insanity under Section 84. Even persons who are under the influence of alcohol are not liable for crimes. When a person commits a crime in the process of defending his life or property, protection is given under Sections 96 to 106. Types of offences. Chapters 5 to 23 contain various offences prohibited by the Penal Code. These are the various chapters, group of offences, and provisions. Offences of similar nature are grouped together under a single chapter. All chapters are important. Do not skip studying any of these chapters. The two most important and densely populated chapters are Chapter 16, Offences Affecting Human Body and Life. This chapter consists of serious crimes like culpable homicide, murder, hurt, assault, kidnap, abduction, and sexual offences. Chapter 17, Offences Against Property. This chapter consists of crimes like theft, extortion, robbery, dacoity, cheating, and so on. These are the other important chapters from the examination point of view. I have tabulated the most important sections in the IPC along with leading cases in a PDF document. If you are interested in receiving a copy of it, put a request to me. Anatomy of an offence. Every provision that deals with an offence has a structure. If we study this structure carefully, it becomes easy for us to understand and remember them. Each offence consists of a section number, title of the provision, core of the provision containing if statement and then statement, explanations, exceptions, and illustrations. This is the text of section 299. You can notice the section number 299, the title culpable homicide, the core of the section that contains the conditional statement. You can notice the three illustrations there and explanation 1. Section number. For the most important provisions, it is necessary to remember the section number. If section number is written in the exams, it makes your answer look impressive. Section numbers are crucial, especially while connecting related provisions. I suggest that you make a list of important provisions and their numbers in a sheet and look at it daily so that you become well versed with the section numbers. I have made a list of important provisions that can be neatly printed on a single A4 sheet. If you need the PDF copy of it, get in touch with me. I will be happy to email the file to you. Title. The title of the provision is written in the marginal note area. For example, for section 299, culpable homicide is the title. Next comes the core of the provision. Consider section 299, which defines culpable homicide. The part highlighted in red consists the if statement. It tells what are the conditions to be satisfied. The if statement usually contains the ingredients of a crime. More about ingredients are discussed later. The part marked with green consists of the then statement. This part contains the consequence that follows. This part states that if those conditions are satisfied, then it will be considered as culpable homicide. Let us consider a part of section 304 which lays down the punishment for culpable homicide. Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life. In the above statement, the text marked in red is the conditional statement and the text marked in green is the consequence. If the condition is met, the consequence follows. In this case, if a person commits culpable homicide, then the consequence is punishment of imprisonment for life. Explanations. Some of the provisions contain explanations appended to the section. These explanations either define a technical term or provide additional guidelines on a crime. For example, Section 299 consists of 3 explanations. The first explanation provides insights on the consequences of causing injury to an already ailing person. Exceptions. Some exceptions are appended to the provisions. The nature of exceptions varies from provision to provision. For example, Section 300 has 5 exceptions listed. Illustrations. To make it convenient for readers to understand the offences, the drafters of the Penal Code have given several illustrations to important offences. Illustrations give examples of when an act is considered to be a crime and when it is not. Writing the same illustrations in exams will make your answers look impressive. Ingredients of a crime. A dish is made up of ingredients given in the recipe. Even if one ingredient is not added, you will end up making a different dish. Ingredients of a crime are the events or acts that constitute a crime. There are multiple ingredients for each crime. In the absence of even one ingredient, it would not be considered as a crime. For example, in Section 299, intention is important. In the absence of intention, an act fails to qualify as a crime. These are the ingredients for culpable homicide. When the word "and" is used between the two ingredients, it means that both the ingredients are necessary. When the word "or" is used between two ingredients, it means that the satisfaction of either of the ingredients is sufficient to constitute the crime. In this example, A consists of an actus reus and B consists of the 3 options of mens rea. Both A and B are necessary. Under B, one among 1, 2 or 3 is sufficient to constitute the crime. Ingredients of a crime can be deduced by examining the main provision, explanations and exceptions. Ratanlal and Dheerajlal book on IPC has ingredients for each offence listed neatly. There are many provisions in the Indian Penal Code that are long and seem complicated. These provisions can be simplified by breaking down into logical pieces. For example, the offence of sedition in Section 124A looks long and complicated. This can be broken down into such logical pieces. Now observe how this provision becomes easy. I have split up the provision into 4 parts. Whoever by words, either spoken or written, or by signs or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, and so on. The provision is all about certain prohibited acts. In the first part, reference is made to the person doing the act, whoever. In the second part, the various means by which such act is done are listed. The act may be done by means of words or signs or visible representation or any other means. In the third part, the prohibited acts of hatred, contempt and disaffection are mentioned. In the fourth part, towards whom these acts are directed is mentioned. These acts of hatred and disaffection are directed towards the government. The rest of the provision is about the punishment, which is relatively easy to understand. The offences found in the code consist of one or more of these constituents. Please note that I have made a broad generalization. There are several exceptions. While making notes for the offences, dividing the provision on these lines will make things simple to understand and remember. For example, let me consider Section 124A. These are the constituents. Examination tips. For any question, the answer should be in the format of introduction, body, and conclusion. In the body, explanation of the provision, discussion of the leading cases, and connected provisions have to be discussed. There are 4 types of questions that can be asked in the exams. For questions from general explanations, general exceptions, and punishments, there will be less content. Hence, a student needs to connect those provisions with the other relevant offences. For example, while answering a question on punishments, reference can be made to important offences where such punishments are awarded. For questions based on offences, write a short introduction. Mention the chapter where the provision belongs to. For example, while writing the answer for murder, mention that the offence comes under chapter 16, Offences against human body and life. Mention the section number. If you can reproduce the provision verbatim, you can fetch good marks. Even if you cannot reproduce the provision verbatim, write the gist of the provision without fail. Mention the ingredients clearly. Write the consequence that follows on the satisfaction of the ingredients. Write explanations and exceptions. Give illustrations. Write the leading cases along with the principles laid down in those cases. You need to discuss at least 3 to 4 leading cases. Compare the provision with other related provisions. For example, while discussing the topic of murder, make a reference to culpable homicide, punishment for murder, and commutation of death sentence. Write a short and apt conclusion. While the chapters dealing with various offences are most important, do not neglect the chapters dealing with general explanations, general exceptions, and punishments. If you are facing Indian Penal Code exam, you need to study all the topics that are listed in your syllabus. Check the previous question papers and practice the topics which are repeated often. Books and references. These are the books that are best, in my opinion, to study the Indian Penal Code. The first book provides a complete commentary on the Indian Penal Code. The second book discusses the facts of important leading cases. It may also be helpful to keep the bare act of the Indian Penal Code for reference. I recommend that you buy a copy of the Criminal Major Acts consisting of IPC, Evidence Act, and CRPC. Links to purchase these books are given in the description. I hope this video helped you to understand Indian Penal Code in a simple way. If you found this video helpful, please like this video and share with your friends. Also, do not forget to subscribe to my channel. Comment below if you have any questions or topic suggestions for my next video. Follow me on Instagram. Check my website for law resources. Thank you.